All right, we're all set.
We're all set?
Yep.
All right. Good morning. We're here to hear the case number 22J384, Devon Crest Management, LLC versus Daniel Gaudet and another. My name is Justice Peter Sachs. Welcome, everyone. Mr. Gaudet, can you hear me all right?
Yes, I can, sir. Thank you.
Thank you. And Mr., is it Ancetil?
It's Ansel, Your Honor.
Ansel, all right. So you can hear me okay?
Yes.
Wonderful. All right, we're here on Mr. Gaudet's appeal of the housing court judge's decision regarding the setting of the appeal bond. Mr. Gaudet, each side will have 15 minutes to argue their case this morning, and you will go first. Since you're on the telephone, not on Zoom, you can't see the timer that we'll be able to see on Zoom, but I'll try to let you know how much time you have left, particularly as you get to the end, just so you can know when it's time to start wrapping up your argument, and then Mr. Anstel will present his argument. We are here primarily, I think, because there's no question, Mr. Gaudet, that the judge determined that you were indigent, but he determined that you did not have a non-frivolous issue to raise on the appeal from the summary process decision. And so he set the appeal bond at, I think it was somewhere in the neighborhood of $6,700. And I'm just getting that order in front of me. $6,931.17, and then ordered you to pay $1,800 per month as use and occupancy while the appeal was pending. So I think the main question before us is, what issue or issues would you plan to raise on appeal from the summary process judgment that would be non-frivolous? Because I have to find that there is a non-frivolous issue in order to waive the appeal bond. So why don't you go ahead and we'll start the timer at 15 minutes.
This is Dan Gaudet. I appealed from the lower housing court after the 27th that I pay in for use and occupancy. And the lower judge erred for the following reasons. Number one, the lower court did not consider the Board of Health Code violation that the apartment has mold and mice, and that the value of the rental is zero. And number two, the lower court disregards our answers in the counterclaim and determination of the rental value to the apartment we entitled in accordance to the Supreme Judicial Court, Boston Housing Authority versus Hemingway, to live in an habitable apartment, and the new owner, after taking over from the older, ignore the building code violations, and the lower court judge erred to deny that the defendant requests for a jury trial. And number three, the lower court judge erred since the defendant has a pending rental assistance program, RAFT, that is ready to pay the landlord, but the landlord knowingly does not cooperate. And so I would respectfully request that the court remand the case to the lower court and order the lower court to consider the diminished value of the apartment based on the Board of Health Code violations.
Okay, so as I looked over the record, this case was decided on the landlord's motion for summary judgment. And I looked at the opposition papers that you filed in response to the landlord's summary judgment motion, and I did not see them addressing the conditions in the apartment. And so if you didn't raise that issue in response to the summary judgment motion, it's not really an issue that you can raise on appeal. You can't raise something on appeal that you didn't argue before the housing court judge rendered his decision on summary judgment. am I mistaken about whether you raised that issue in arguing against summary judgment?
No, you're not mistaken on that right at the moment.
Okay.
But I got informed that that is an issue that I should have brought up before. I've had mice all winter long, and then I got rid of them myself with some mothballs. Makes the house smell like crap. And there's mold in the bathroom too.
Okay. Well,
and I also live with my son who has mental issues going on with him right now. He hasn't worked in 2 years, and I'm dealing with him too.
Okay. I wanted to ask about your claim that the landlord is retaliating against you for perhaps joining together with other tenants to protest the conditions in the housing or to take other action with other tenants. And the judge in his summary judgment decision said that there was no dispute of fact about that because the tenants meeting that you had mentioned previously occurred on July 29th of 2021, whereas the landlord had already sent you a notice to quit to terminate your tenancy on July 14th, 2021, which was two weeks earlier. And so it couldn't, the notice to quit could not have resulted from your participation in the tenants meeting. First of all, are the dates of that accurate as far as you know? In terms of—
Yes, sir.
Okay. And is there some evidence that you put before the judge about when the any action that you were taking before July 14th, 2021, when the landlord served the notice to quit on you, that the landlord might have been retaliating for? In other words, the tenants meeting occurred after the notice to quit. Is there something that you did before the notice to quit that the landlord might have been retaliating for in serving the notice to quit on you?
Yes, I said that in my answer.
You said that in your answer. All right. And what did you say in your answer?
Landlord retaliation because tenant unit participation. That I'm trying to get out of this place and it's not easy, And I requested for a jury trial. And I'm working on it. I'm trying to get out. I don't want to be there as much as they don't want me there. So,
yeah,
it's just things are difficult, and I need more time.
Yeah, I understand that, and it seems like you're in a difficult situation, but I have a very limited role at this point, which is to determine what kind of issue you could raise if you were able to proceed with your appeal from the summary judgment decision that would have some merit to it, that would not be a frivolous appeal. So I just want to explore the issue of your claim of retaliation a little further. Did your answer give any specific dates or acts that the landlord that you took before July 14th of 2021 that the landlord might have been retaliating for? In other words, was there another tenants meeting, or did you make some protest to the landlord yourself? Anything that happened before the notice to quit was served on July 14th?
Yes, I called the landlord and complained about the quit notice, and I was paid in full, and these people are retaliating because we're fighting them.
All right. Did you, I looked at your summary judgment opposition, the papers that you filed, and I didn't see anything in there specifically, in particular in your affidavit, that referred to when you were protesting to the landlord. I did see a mention of an association meeting to protest the landlord's conduct. I saw that in your affidavit attached to your summary judgment opposition. I didn't see any specific fact that would create a dispute that would you would have a jury trial to resolve about when that association meeting occurred or when you otherwise made some protest to the landlord. Is there anything in the record that you could point me to that would create a dispute of fact about when you protested to the landlord or met with the tenants, other tenants, to protest the landlord's activity?
Well, I wanted to testify, but the hearing was canceled for summary judgment canceled.
I'm sorry, the summary judgment was canceled? I'm not sure I'm following that. I do know, I mean, the judge's decision said that he held a hearing on the motion for summary judgment at which the landlord's attorney appeared, but you did not appear. Is that accurate?
No, that was canceled.
All right, let me just refer to the judge's summary judgment decision. He says plaintiff's motion, that is the landlord's motion for summary judgment, was scheduled for a remote hearing on April 25th, 2022 in the Lowell session of this court, meaning the housing court. The plaintiff, but not the defendants, appeared. The defendants did file an opposition to the plaintiff's motion, which I consider in deciding the plaintiff's motion. So he says that the judges, go ahead.
That particular day, I was there, and I went to dial in, and I was dialing the wrong number. I had some technical problems, and then when I got through, they did not let me participate in the hearing, appear in that hearing.
Did you bring that to the attention of the judge afterward?
No, I didn't.
Sorry, I'm not hearing you, Mr. Gaudet.
After the hearing, I thought it was done. I didn't know what to do after that.
Okay.
I was there, I was on the phone, I was calling, and I finally got through. I didn't get to participate.
All right. Is there anything on paper in the record from the housing court that indicates that you filed a motion for reconsideration or any other kind of motion with the judge that said, hey, I wanted to participate in the summary judgment hearing, but I was not able to because of technical problems?
They had called the clerk that morning and let her know, or him, I can't remember if it was a girl or a guy at that time, but that I was having problems getting through, and then I realized I was dialing the wrong number. They gave me the right number, and then when I went to get through, they wouldn't let me participate.
Okay. You have about 3 minutes left. I just want to let you know. Is there any other issue besides the ones that you've mentioned already, which would be the conditions and the retaliation? Oh, I know. I wanted to ask you about the rental assistance. So currently you have an application pending?
Yes.
Okay. And with what agency?
Matter of fact, I have to call them when I'm done with this.
Okay. And if that application was granted, would the rental assistance pay the amount of back rent that the judge found that you owed, which was, I think, $6,900? It would pay that, and it would also pay the use and occupancy going forward?
Yes.
Okay. When do you expect a decision on that rental assistance application?
I got an email from the lady this morning, and I got to call her, and I'm hopefully by September 2022.
Okay. And you said that the landlord had not cooperated with some aspect of the rental assistance application or program. Can you tell me more about that, please?
Oh, I originally applied for RAF, and they kept on asking me for a packet from the landlord, and I'm like, what packet from the landlord? So I messaged the lawyers, and I guess when they sent me information back, it must have went in my spam because I didn't get the information. I was supposed to sign a piece of paper, and then so I did sign that piece of paper after and submit it to them, and then I reapplied for RAF. So that's when I'm in the process now of, like I said, the lady just messaged me the other day and asked me if I heard from them yet, and I said no, I haven't. So I'm going to call this lady after I'm done with this and find out what the status of that is going.
Okay. Did the landlord finally send you the package that you needed for the application?
No, I haven't got a packet from them. I don't know if they sent it on to RAF themselves or not.
Do you still, is it your understanding that you still need something from the landlord for their application?
I'm going to call this lady, but I believe so, yes.
Okay. You've got about 30 seconds left, so is there anything you want to say in conclusion?
I did not participate in that summary hearing because of my technical issues, and wasn't able to be part of it at that time. And I would like to still get a jury trial, and need more time, need money.
Okay.
And that's it, Your Honor. Thank you so much.
All right. Thank you, Mr. Gaudet. All right. Now, Mr. Anstel, we'll hear from you representing the landlord, Devon Crest Management.
Morning, Your Honor. Robert Ansel for the plaintiff. I know that you have a great awareness of the facts. Thank you for reading the briefs in anticipation of the hearing today. I will provide you with a brief summary of where we are, knowing that you've read our briefs. Mr. Gaudet moved into his unit in February of 2021. Clients bought the property in May. They sent a notice to quit on July 14th, 2021, which was a 60-day notice to quit, now over a year ago. Since that time, Mr. Gaudet has not made a single payment towards his rent, and he has consistently and persistently said that he needs more time and more money to move out. Your Honor, during the course of Mr. Gaudet's argument, you had asked a number of questions about what questions he has preserved for appeal and what he hasn't. If Your Honor reviews the answer that was filed in this case, you will note that some of the same issues that he raises on appeal for the first time, he actually struck out of his answer. For instance, discrimination, bad conditions of the property, interference with quiet enjoyment, other defenses and counterclaims, evictions and foreclosures. Everything is crossed out. What he did answer is that on the standard form answer, he writes in paragraph 73, I need more time. That has been his request since day one, and that time has now run out. Mr. Gaudet's testimony that we hadn't cooperated with RAFT is patently false. We addressed that in our motion. My client owns a number of properties within this development, and they are moving forward with a series of evictions with the goal of doing major renovations to the property. We have accepted RAFT in other cases, and we asked Mr. Gaudet to fill out some paperwork so that we wouldn't reestablish a tenancy, but we have never once said that we would not accept RAFT payments. Also, during the course of our hearing in front of Judge Del Porto relative to the bond, Mr. Gaudet didn't raise a single issue, despite the opportunity to testify about the condition of the premises. He now says that he should pay zero in rent because there is mold, mice, and other issues. That there's nowhere in the written record nor in the verbal record that he raised that issue prior. So this is also consistent with the numerous violations of various court deadlines and orders. We had a pretrial conference because he requested a jury trial. I had called him on 4 separate occasions to ask him if he was going to submit a pretrial statement. He failed to do such. He also failed to provide answers to discovery. We did file a motion in limine concerning that. The judge did not act on that because of the motion for summary judgment that we also filed in this action. Simply put, Mr. Gaudet has no viable defenses to our eviction action. He hasn't paid rent in over a year now, and it's time to move forward. Setting the bond is a very important aspect of this case now in light of the glacially slow pace that housing court finds itself in. To have a case where we filed a notice to quit over a year ago, we now have a judgment, but it unfortunately, with the pandemic, things have really gone slow in the housing court. So we are looking for the order that Judge Del Porto put together. The use and occupancy rate was set at $1,800 a month. We had testimony to support that $1,800 a month. Judge Del Porto also had an affidavit, which was part of the record. Mr. Gaudet did not say that the rent was too high, too low, or matter of fact, he didn't testify at all as to the amount of the rent. Simply put, he does not have any viable defenses other than his non-legal one that the housing market is difficult to find a place for.
Okay. Thank
That's
you.
essentially what our argument is, Your Honor. I'm more than willing to address any specific issues that you have. This is a case that we've had over 30 separate docket entries in a housing court action. It's an exceedingly high number for a summary process action. We have been responsive to Mr. Gaudet. We've offered numerous relocation incentives. We've really tried to work with him in every capacity, and his testimony today or his statements today that he is working with somebody from an agency that he doesn't know the name of that he's supposed to call back today is consistent with where this case has been. So.
Okay, a question about rental assistance. In the ordinary course, if a tenant were applying for rental assistance, what role would the landlord have in furnishing information either to the tenant to give to the agency or directly to the agency?
The most common rental program is wrapped, and wrap requests your proof of your taxpayer identification number, and it asks for a copy of your deed. It also asks for a copy of your lease and a ledger. We have provided that information to numerous other tenants at Devon's Crest. My client also owns a number of other rental properties throughout Massachusetts. It's a very common everyday practice. The system is done electronically, and they predetermined those four documents essentially. Yeah. Taxpayer identification number, lease, ledger, and a rental history. The wrap program would be available to pay the past due rent as well as some payments in the future. Mr. Gaudet, although we testified that he has $25,000 in funds between him and his son, he realized that is not reflective of Judge Del Porto's order, but he had testified that he does have those funds. He has some concern about a potential tax liability concerning those funds, but he does have the funds available. The RAF program does not ask much of the tenant relative to proof of income, assets, or lack thereof. So the funds have been and were available. My client's desire is to complete the termination of the tenancy, which is tenancy at will, and there is a no cause eviction. They are seeking to do major renovations to the property. This is not, although it is now a back to rent case, and my client hasn't been paid rent in over a year. It started as a no cause eviction, and the purpose of the no cause eviction is to do major renovations.
Understood. Has either Mr. Gaudet or any rental assistance agency asked you for that package of documents that you mentioned?
Yes, and we've supplied that, and we also addressed that in our brief that we filed with the court, which is on page 5 of our brief.
Okay, and I'm looking at page 5. Is there anything attached in the way of an affidavit or otherwise?
No, there's a document that what we attached, which we sent Mr. Gaudet a motion, not a stipulation, so that we weren't going to be reading the tenancy. And there's also a chain of emails reflecting my client's conversation with Mr. Gaudet. So and we also went over the rental assistance issue in April, May, in June. We more than willing to accept rental assistance, but again, that this case is not a back due rent case, which may have prevented us at the start of going forward with eviction.
Okay, let me ask about Mr. Gaudet's retaliation claim. The judge says that there was no disputed issue of fact regarding retaliation because the notice to quit was served on July 14th and the tenants meeting wasn't until July 29th, I believe. Are you aware anywhere in the written record before me of any claim by Mr. Gaudet that he took any protected activity before that July 29th meeting?
No, there isn't. Your Honor, again, No, I don't
Okay.
have any information. He did raise in his answer that the other people worked together not to be evicted. He did raise that in his answer to the original complaint.
Right.
But my client sent out the notices soon after acquiring the property. There was a tenant organization that had a few meetings. I don't know anything about Mr. Gaudet's involvement or lack thereof in that tenant organization, but it's our notice to quit certainly was before anything that had arisen with that tenant.
Okay. Do you have any knowledge of what or response to what Mr. Gaudet said about his technical difficulties in participating in the remote hearing on the summary judgment motion?
I think that his statement is exceedingly disingenuous for whatever reason. The day that we had our hearing, there were a number of cases that were on, maybe 35 cases or so. And his statement that he couldn't get in and that it was over by the time that he called, that day, the session lasted from, I think it started at 9 to like 12:30. It was a very long session. There would have been 3.5 hours for him to call in to participate in the hearing.
Okay.
So, I don't know that. I have spoken to him a number of times. I think that if he wanted to participate in the hearing and he was having a difficult time getting in, that he would have picked up the phone and called me. I did not hear from him. He did not. What he didn't do in this case is file a motion for reconsideration, nor did he request a stay, requesting additional time. He appealed the court's order, and he doesn't have any meritorious defenses relative to the appeal. The judge may have granted him a stay for of execution for various reasons, but its appeal is not properly before the court.
Okay. All right, you've got 45 seconds. Anything else you want to say in conclusion?
If this case was if he had counsel, I'd unequivocally be seeking sanctions. That's not my way in which I practice. This is a pure abuse of the process. He's had over a year to move out. He not only has he not moved out, he's also had plenty of availability of public resources. He hasn't taken advantage of those. He finds out about a defense and then jumps onto that, but it's always been too late and 100% irrelevant to the facts of this case.
Okay. Thank you, Mr. Ansel. Thank you again, Mr. Gaudet. I will take the appeal under advisement, and I'll try to get a decision out to both of you as quickly as I can.
Thank you very much, Your Honor.
And we're adjourned.
Thank you, Your Honor. Thank you.
Thank you.